But yeah, good morning and thank you to everyone again for joining us for Cilla's Employment Law Update. We are recording the session, so if you need to jump off or if you came on late and you've got colleagues with you, we will send out that link early next week. But I would like to start by acknowledging the traditional custodians of the various lands on which we work today and pay respect to elders past, present and emerging, and extend that respect to any First Nations people joining us today. So a brief introduction from me. I'm Angela Franks, the partner for Fraser Jones here in Australia. We are a global recruitment and search business, but in Australia we have offices in Brisbane, Sydney and Melbourne. For anyone who's been tuning into our webinars for a while, you know that Cilla's HR Horrors, we run them every October and it's been very interesting and I look forward to this every year. But this session, Cilla will walk us through the latest industrial relations reforms, including same job, same pay principles for labour hire workers and the criminalisation of wage theft, which I'm getting alerts about every day at the moment. So we'll also look at the gender pay gap, fixed term contracts, and then I think high on everybody's minds at the moment is the challenges of AI and breakthrough technologies like ChatGPT. So, and then for the HR Horrors, we'll go over a recent case in the High Court about a drunken employee. Right, so we're always delighted to partner with Cilla, and thanks again for running the session. But please use the Q&A button as we go. So I think there probably will be a lot of questions, and with a lot of content, I'll do my best to monitor the Q&A rather than the chat because the chat constantly moves. So yeah. We'll keep questions to the end, but I'll do my best to cover them all. Over to you, Cilla.
Thanks so much, and welcome everybody. Thanks for joining again to the extent that you've joined us before. So yes, as Ange mentioned, there is a pretty tight amount of content to get through today. I'm going to go through at a high level just some of the reforms, and you guys would all be acutely aware that there have been a lot of reforms. So I'll just be tapping in on some of the main aspect of what is 3 different pieces of legislation, talk about wage theft, talk about the gender pay gap, fixed term contracts, AI in the workplace, and then a case study, which I'm hoping we have enough time to get into. So that is the very heavy agenda. First up is the employment law updates. And I wanted to just talk about 2 key updates that aren't legislative reforms. These are based on case changes, but they are pretty significant. So I thought for the HR crew it was worthwhile highlighting them today. So the first one is about the new annual leave requirements in terms of shutdowns for awards. So at a high level, there are new rules for shutdowns, such as Christmas and New Year period, and these came into effect on the 1st of May. And they are in most modern awards. So many of your businesses that you work for will be covered by modern awards, whether it's the Clerks Award, the Professionals Award. So if you've got award employees, this is going to be relevant to you if you do an annual shutdown, whether that's at Christmas or Easter. And the main change in terms of the impact of this award change is that employers will no longer be able to direct employees to take unpaid leave during a shutdown period if they have no leave accrued during that period. So it used to be that a business would just say, we're shutting down between X and Y dates at Christmas. You need to take leave. Most people would take annual leave if they had it, or long service leave. But if they didn't, it would necessarily be a period of unpaid leave. So now these very employee-friendly changes mean that an employer can only direct employees in certain circumstances. So if the employee doesn't have enough leave, then the employer and the employee can agree, and the key term there is agree, that they will take unpaid leave, but they can't be directed to take unpaid leave. Or alternatively, if it's permitted by the award, they could take a period of leave in advance, so essentially tapping into next year's accrual, for example. But essentially, if the employee doesn't agree, then on its face, the employer must, as we've got here on the slide, find work for the employee to perform, or alternatively pay the employee for the period not covered. So it's one to be thinking about now. If you have a Christmas shutdown, the model clause also introduces a standardised 28 days written notice to employees of a temporary shutdown period. So that you don't find yourself in a period where you might have to pay employees who don't have leave to not do anything, it's best that you start thinking about this change now, really, given we're nearly halfway through October. So the second thing that I wanted to talk about is a court decision that impacts on public holidays. So again, something to be thinking about at this time of year as we go into the Christmas period, and even Melbourne Cup's around the corner. So the federal court delivered this significant decision, and it found basically that a company that required its employees to work on 2 public holidays in 2019, but didn't request whether those employees could in fact work those days, had contravened Section 114 of the Fair Work Act. So essentially the effect of this decision is that employees that are required to work on public holidays need to first be requested whether they can actually work those days. And it needs to be a reasonable request. So the request must be made. It must be reasonable. Now, employees can refuse the request. So again, it's important if you are working through that Christmas period, and they can only not refuse if the request is reasonable and their refusal is unreasonable. So essentially, a little bit of legal jargon, but essentially both parties need to be acting in a reasonable way in the both request and then in either the refusal or the acceptance. So really this is quite a significant decision for businesses, especially, for example, retail that work through all of those public holidays that we get over the Chrissy period, because quite often businesses will just have an opt-out system. So people will be rostered, and then if they want to take leave, then they'll need to tell their boss or their supervisor, I can't actually work those days. And it worked that way. Whereas now, as I said, the employer needs to make that reasonable request first before scheduling to people to work on public holidays. So it's quite a significant change. And importantly, because of that case, and because it is a case law change that's highlighted this issue rather than a legislative change, the Fair Work Ombudsman have received quite a lot of complaints from employees where they have been required to work where there wasn't this reasonable request. So we have a lot of businesses that are looking at their practices to ensure that they are okay for the go forward in terms of the Christmas period that's coming up, but also thinking about whether they've got policies or procedures in place that actually essentially fall foul of how these public holidays arrangements should work in practice. So just something to have a think about, again, in the lead up to the holiday period. So that's the quick update. That's not the reforms. Now I want to talk about the industrial relations reforms that have been introduced by the Fair Work legislation, the protecting worker bills, plus the 2 subsequent bills. So the Protecting Worker Entitlements Bill is now law. It was passed on the 22nd of June. So I talked about that a little bit the last time we spoke. So that is law now. There are obligations that you need to be complying with presently. And then I'm going to talk about some of the other second and third tranches of the legislation as well. So in terms of the first tranche of legislation, they were really quite, uncontentious in the main. A lot of them were just fixing up some gaps or some concerns that the government had in terms of how the Fair Work was operating. And this slide has the second tranche reforms and what they talk to. And as I said, there's a lot of content. So I'm really just going to tap into these things in a high level way. And then if there's specific questions, we can answer them at the end, just so that we can get through the content. So the first change relates to superannuation, and these changes are going to be effective 1 January next year. And the thrust of that change is that the superannuation guarantee, which presently, or prior to this legislation just existed in superannuation legislation, is now brought into the national employment standards that are into the Fair Work Act. So you guys are probably familiar with the Fair Work Information Statement that you give your employees on the commencement of their role. Now, the NES, the National Employment Standards, will refer to this obligation to pay superannuation. Of course, that's not a new obligation, but it's now under the auspices of the Fair Work Act, as well as the super legislation that sits separate. So that's not contentious. It's just bringing it under the Fair Work Act. But the thing that is important and quite a significant change is that historically, if an employee wasn't paid superannuation, that was a matter for the ATO and the tax commissioner to consider in terms of regulation. And so obviously relying on a government department and the tax commissioner to regulate that, meant that not everything was captured in terms of super breaches. So now these new changes and bringing it under the Fair Work Act means that both employees as well as the Fair Work Ombudsman can bring claims for unpaid superannuation. So it's just making it much easier for both the regulator, the Fair Work Ombudsman, as well as employees to bring claims in relation to super that hasn't been paid. So that's super. There's also been a change in relation to gender neutrality and expanding the unpaid parental leave language. So that's effective 1 July this year. And essentially what that means is that both parents, the man and the woman, or the two different partners, it's essentially not gendered language, can both parents, irrespective of gender, can go on 12 months unpaid parental leave within 24 months of the birth of the child, and 100 of those days can be taken flexibly. So that change really is just acknowledging gender fluidity and the non-binary nature of gender that we adopt in progressive workplaces. So hopefully that's not contentious for any or many of you. Probably the most relevant thing on this slide for many of you is that the changes expand access to employee authorised deductions. So you might be aware that for a deduction to be lawful, it needs to be for the employee's benefit. And previously you needed to get recurring authorizations from the employee, written authorizations, where the amount of money changed. So say, for example, an employee wants a deduction for their union member fees. If the union fees went up, then a new authorization would need to be given. So this change means that the employee can give a single authorization for recurring deductions. And if those deductions change in terms of the quantum, then there's not a need to make a new authorization. So something that eases the administrative burden for both employees and employers. For migrant workers, there's been some increased protections. And the nub of it is really that if there is a breach of a visa, that doesn't impact the validity of their contract, their employment contract, or their independent contractor agreement. So you'll recall that quite often we would have contracts that say, if your visa status is no longer valid, or if you lose that, then your employment ends. It's essentially giving them additional protection in those circumstances. And there's also been changes to introduce long service leave for casual coal mine workers. So that's a very bespoke thing that I don't plan to talk about in any detail, but if you're in coal, it will be relevant to you, and that's from 1 January next year, or if the Act is proclaimed earlier, it might be in place a little bit sooner. So this is future reform based on the Closing Loopholes Bill. So we've had the first and second tranches of reform. I talked a lot about this first last time, a little bit about the second just now. Surely that's enough IR change for us, right? Wrong. There's still more ahead. So on the 4th of September, the federal government introduced this amending Closing Loopholes legislation. And really the most significant change is the change to close the Australian labour hire industry's purported loophole. So on the screen, we see the key changes that have come into place in this closing loopholes bill. And I want to talk in a little bit more detail about gender pay gap and also fixed term contractors, and wage theft. But I just wanted to mention very briefly the others, just so that you can get a little bit of a feel on the changes at a higher level. So in relation to labour hire arrangements, essentially this legislation seeks to address instances where employers have negotiated wages for their own workforce, and then they engage under an enterprise agreement specifically, and then they engage a labour hire company and pay significantly lower rates. And a lot of this goes on where you have an EA in place, and then your labour hire people are paid at award rates, for example. And so essentially that loophole is closed so that employees that are working side by side on a site doing the same job will be paid in the same way. So that's the main labour hire change. It will have an impact on some businesses. There are some exemptions for small businesses, or where the labour hire provided will be for less than 3 months. So just to deal with, for example, surge periods. And there's also some anti-avoidance provisions to avoid the exemption being abused. So that's the labour hire arrangements. Casual employees, we love casual employees. It's one of these constant things that it seems to be changing for a nightmare for both HR and employment lawyers. But you'll recall that there was a change where there was an introduction of the definition of casual employee. Complementary to this, the new reforms now introduce this objective test to the meaning of casual employee, so that the practical reality of the true nature of the employment relationship is considered. So essentially, if there is a firm absence of a commitment of ongoing indefinite work, then these would be people that would be considered to be casuals. And the changes also propose that casual employees will be able to request full-time or part-time employment after working for their employer for 6 months. And that's a 12-month period if you're a small business. So again, just more support for casual workers, noting again that the casualisation of the workforce does have a disproportionate impact on women. And a lot of this, a lot of the government's changes do go to trying to address the gender pay gap, which I'll talk about in a moment. So then we have independent contractors and gig workers. So again, this bill proposes that the ordinary definition of employee and employer that has historically assessed the full nature of the relationship and involves a multi-factor test basically come back. So we had some high court cases in JAMSEC and personal contracting where essentially we had an employer-friendly analysis that essentially the contract was king, and if you had an independent contractor agreement, then the person was an independent contractor. Now we are going back to the previous multi-factor test where you look behind the contract to the actual substance of the relationship. So again, the focus here is when you're engaging a contractor, think about, is it their personal service that you want? Can they delegate their duties to someone else without that being a concern to you? Do they provide their own tools and equipment? Do they have their own insurances? All of those considerations that prior to the High Court cases we had to think about, we're now having to think about again. So essentially it's a bit of back to the future going on there. And the only other thing that I wanted to talk about, and I haven't gone into the changes to workplace delegates, and I haven't gone into industrial manslaughter, but if we have some time, I can talk about it at the end. But I did want to just talk about the changes in relation to discrimination, because essentially these reforms propose stronger protections for employees who have been subjected to domestic violence, and essentially it prohibits the termination of employment on the basis that an employee is experiencing or involved in family or domestic violence. and it prohibits the inclusion of terms that are contrary to that in enterprise agreements and awards. So again, it's just bolstering those protections. Again, something that, on paper will have a disproportionate benefit to women who are more often than not the victims of domestic violence. So there have been more changes around enterprise bargaining. I talked a little bit about that last time, so I'm not going to go into that. And it'll be March before we know it, and we might be having another one of these sessions, and at that time we'll go into it when this bill actually becomes law. So I said that I was going to talk about wage theft, and this is probably one of the most significant changes proposed by the closing loopholes legislation. And the main thing to bear in mind is that the effect of this change is that it criminalizes wage theft. So this is a very, very big change. And in terms of the background, and Ange and the Fraser Jones team will share these slides with you. So I'm conscious I'm going through quickly, but you'll have these to refer back to. But essentially, there was a Senate inquiry in 2019 into underpayment of employees, and it found basically that the current regulatory framework was inadequate for pursuing wage and superannuation theft, and that it found that in certain sectors, wage and superannuation theft was rife. And so there was a big problem that was made very clear in the Senate inquiry in 2019. And it found that wage theft was more prevalent in certain sectors, that people that are on temporary visas and migrant workers where they might have undocumented passports and the like were quite often the victims of wage theft, and also arrangements where there's sham contracting and the like in both labour hire as well as the gig economy. So here we see a significant change where wage theft becomes then a criminal act. So this slide just highlights the penalties that exist. So as I'm talking about wage theft, and it's important to understand that wage theft is defined as the deliberate underpayment of wages. So where you're withholding those entitlements deliberately. So it isn't a situation where payroll stuffed something up or we made a mistake. This is the deliberate withholding of wages. And note that because it is a criminal test, the test is then beyond reasonable doubt. So it's different from the civil burden of proof that the Fair Work Ombudsman has to prove these cases. So understandably, where we're talking about a deliberate arrangement to undermine people being paid what they should be, there are significant fines. So on the top, we have the fines for companies, which is the greater of $7.825 million, or 3 times the amount of the underpayment. So what that means is that you might get a 7.8 mil fine. If it's a huge underpayment, and that's actually more than 7.8 mil, it will be 3 times that underpayment. So this gets into crazy huge amounts when companies are essentially doing the dodgy and are not paying their employees. So they are the contraventions for intentional wage theft for employers, for the company itself, and then for individuals that are involved, then you see the greater of 1.565 million. So this is for an individual that's been complicit in this arrangement, or again, 3 times the amount of the underpayment, or 10 years imprisonment. So I know that a lot of you are HR folk. This really does put a really strong focus on due diligence, on ensuring that you're doing the right thing, on ensuring that the businesses that you're working for aren't engaging in practices that could be seen to be deliberate underpayment of wages. So as I said, the prosecution will need to prove the elements of the underpayment beyond reasonable doubt. So, it's not just that somebody says that they've been underpaid. And again, it's not just where it's accidental or inadvertent. A genuine mistake isn't going to be caught by these provisions, but where organisations are deliberately doing this to employees, like quite often occurs with these migrant workers, then this is the focus of this legislation. The bill also encourages self-disclosure by about potential wage theft, and it provides a safe harbour framework, essentially meaning that if a company self-discloses an alleged wage theft contravention and reaches an agreement in cooperation with the Fair Work Ombudsman, then the Fair Work Ombudsman will exercise their discretion and considering a range of factors in essentially reducing the penalty. And that might be whether the employer made a frank and voluntary complete disclosure, or their past record in terms of compliance with the Fair Work Act. So, again, we currently have the Fair Work Ombudsman bringing prosecutions against companies. This isn't a new thing for wages, and again, self-disclosures are also not a new thing. And so I always advise, if you're going to make a disclosure, get your house in order and understand what you're disclosing before you do that. But here, where we have this criminal test now, it will probably mean that we will be seeing more self-disclosures because people won't want to run the risk of those significant penalties that you can see on the slide if they don't actually fess up to a problem. And again, noting it needs to be a deliberate arrangement. So hopefully none of the businesses that you will work for are at risk of falling foul of these new changes. So now I'm going to move on to gender pay gap, and I am moving through things quickly. There will be time for questions, but there's just so much content here. So gender pay gap, I mentioned a little bit about this when we had the presentation in March. So this slide just talks about some stats. 14.6% of women earn less than men. So essentially, as of May, the national gender pay gap is around 13%, and so that's the more recent data that's just come out. And you may recall that as part of the Labor government's or the Labor Party's platform, they said that they want to focus. Albanese said he wanted to focus on ensuring that Australia deals with its gender pay gap. So there's a few different things in the legislative changes that essentially talk to this issue, and they're on this slide. So the first one is gender pay reporting. So companies with over 100 years, it says 100 employees need to report on their gender pay gap to the Workplace Gender Equality Agency. So and employers have needed to report on this since 2012. It's not a new requirement to report to WGEA. However, as of early next year, now companies need to be reporting and also making their gender pay gap public. So if you've got a concern about gender pay gap in your organisation, now's the time to start looking at that. Interestingly, the Attorney General is consulting with WGEA with partnerships. So I've been involved in some discussion about bringing partnerships into the mix as well, because as you might be aware, these reporting requirements are on companies. So law firms, large accounting firms that are partnerships, so they're not actually companies, fall outside with respect to the partners like myself who are not actually employees. So essentially, we're going to have a situation where in the next few years, every organisation is going to be reporting on the gender pay gap, and hopefully that means that we can work towards closing it. So reporting is one part of it, and essentially with it becoming public, there's an element of name and shaming involved there. Then we have the banning of pay secrecy, and I spoke about this a little bit last time, so I'm not going to go into it. And now that I've got this big on the screen, I see a typo in the word contracts. My apologies. But essentially, you'd probably be aware already that there is now a workplace right that employees can ask each other and disclose or not disclose their pay to their colleagues or anyone else outside of the organisation. So pay secrecy clauses in contracts have no effect. There is a positive right under the Fair Work Act, under section 340 of the Fair Work Act, that means that people have that protection. And if they are treated adversely on account of asking somebody or telling someone about their pay, then they'll be able to bring an adverse action or general protections claim. So again, that's a change that is geared towards addressing the gender pay gap, because if there's no pay secrecy, then organisations are less likely to pay men more than women if they're doing the same job. There have been some panels set up for specific sectors, so where there are a lot of women. So the care and community sectors have the ability to have an expert panel to then look at their pay and wages, and there's been a significant funding allocated to establish these panels. So if you're in the care and community sector, then that's a very easy way for an employee to get a review on whether their pay is appropriate. And the other notable change is that gender equity was added as an objective of the Fair Work Act. So it's one of the guiding principles. So, we can expect that our commissioners and the judicial members of the Fair Work Commission will just have this at the back of their mind in hearing unfair dismissals and hearing general protections claims, because it now is one of the underpinning pillars of the Act. So, fixed term contracts, I'm just going to get these little bits up on the screen. So, these changes are effective 7 December. There's a lot of different data points that say 6 December. 7 December is the actual effective date. And they're serious changes. They affect most organisations. So the nub of these changes is an employer must not enter into a fixed term contract with a non-casual employee that's longer than 2 years, has a term including extensions or renewals of longer than 2 years, can be extended or renewed more than once, or is consecutive with a previous fixed term contract where the employee is going to be performing substantially the same work. So essentially, you're not going to be able to have this situation where you have rolling fixed term contracts, where we can use fixed term contracts to avoid headcount. There's all manner of different reasons why organisations use fixed term contracts. They're obviously going to become, decreasingly attractive. I have just seen a question about, is it fixed term, max term? It is essentially max term contracts as well. It's not a true fixed term contract. There's also an ability for the Commission to resolve disputes. So they've got now a discrete power to resolve contractor disputes around this. So it's a big change. It means that, a lot of the benefits of fixed term contracts fall away, which, as an employment lawyer that's been doing this for over 20 years, I think it's probably a good thing, because unfortunately you do see businesses that just take a lazy option and use a fixed term contract, and then they roll them over. And there's a whole lot of risks where, there's a great risk that the employee is seen to be a permanent ongoing employee in any event, but they haven't been paid their, annual leave and their other employee-based entitlements. So it's really ensuring that these fixed term arrangements aren't in place for longer than 2 years. Now, happily for many of you, there are exceptions. So this slide talks about the exceptions that exist. So the first one is that they perform a distinct and identifiable task with specialised skill. So if you, for example, need someone and it's only for a 5-year period and then you're never going to need them again, and it's for a specific skill, then that would fall within that exemption. Again, if it's a training arrangement, that's part of the exemption. Happily, for people who have sort of seasonal peaks and troughs, if they're undertaking essential work during a peak demand period, that will be an exception. Again, in emergency circumstances where they're replacing an employee. One that's good news for many organisations is if they're earning above the high income threshold, which is presently 162 grand, they also fall out of this. So really it is, these changes are geared towards protecting people that aren't high income earners. And the basis for that rationale is that high income earners are going to have enough negotiating power that they won't essentially be able to be taken advantage of, whereas lower income earners don't have so much negotiating power when they're negotiating the contract. If it involves government funding of more than 2 years and there's no reasonable prospects of funding being renewed, then again, that's an exemption. And we've got lots of pro bono and clients that are in sort of scientific and engineering spaces where this has been a real discussion about, well, we can't employ them. You know, the project or the research goes for 5 years. What the hell do we do here? So happily, that's an exemption. And again, if they're employed in a governance position with a time limit, then that's also going to be an exemption. So there is also a broad exemption that if it's permitted by a modern award or the Fair Work regulations, then that will also be an exemption, and you'll obviously be allowed to do it if the modern award or the Fair Work regs allow it. So also there must be a fixed term contract information statement provided to your fixed term contractors, so they understand these changes. And again, there's a reverse onus of proof. So the employer bears the evidentiary burden to prove these things if it's relying on an exemption. And there needs to be really clear and convincing information to support why you've got an employee working for longer than 2 years on a fixed term. And yes, as I've said, you might have these changes, and if there are clauses in a modern word that allow it, then that's obviously going to make it okay. So this slide just goes through, in case you're not scared enough, noting that it's just around the corner, the consequences for non-compliance. So it is a civil remedy provision. It means that you can be on the hook as the HR advisor that's involved in it, as well as the company, in the same way as underpayments and the like. Contractual terms that you have in place that are fall foul of this essentially avoid, and the employee will become an ongoing employee. So it's really important to get your house in order in terms of contracts that you have in place. And of course, there's anti-avoidance mechanisms to avoid a sort of sham contracting arrangement. So it's really important that you have a look at your workforce, look at the composition of the workforce. Are you using lots of fixed term contracts now? Look at your fixed term templates to ensure that you've got a placeholder there that says this cannot be longer than 2 years, assuming that you don't fall within the exemptions. Just putting those mechanisms in place to prevent a situation where the business that you work for or that you own might fall foul of these steps. So really have a think about workforce planning, think about whether any of those exemptions apply, look at your templates. And then really, I think it's helpful for HR professionals and employment lawyers or just sort of GCs or lawyers generally that are working in-house to be thinking about whether you need to develop guidelines on the prohibitions, on the exceptions, so that it's not a taxing discussion that needs to occur every time that you engage a fixed term contractor. So essentially, can you be developing a cheat sheet that your organisation can rely on if and when it's employing or engaging rather fixed term contractors? So 1141, we've now got through the legislative reform. So now I want to talk about AI, and hopefully all of you are aware about what generative AI is. It's essentially, artificial intelligence, where and generative AI and ChatGPT in particular are a form of AI where they can create text, images, and generate content based on inputs that you put in, as well as the information that's available, i.e. the internet. And we're seeing a really significant use of ChatGPT and other AI chatbots. It is the fastest growing consumer application in history. So I'm not going to go into what AI is. What I want to talk about is just the impact in terms of the workplace. So interestingly, a study that KPMG and the Uni of Queensland did this year found that only 34% of Aussies are willing to trust AI systems. Notwithstanding that, AI and these platforms are being used a lot. You need to assume that employees in your organisations are using ChatGPT. Now, that's not necessarily a bad thing. There are a lot of awesome things about generative AI, It can save time and efficiency. It can create draft content. It can rewrite existing content, usually better than a human might be able to do it. It can summarize, it can analyze data. You can obviously use chatbots to have a conversation, so it's making the interface quite easy. And it can create images, videos, and audio. So it's a really effective tool when used appropriately. The limitations are, however, quite concerning. So you may have heard about hallucinations, and that is essentially a phenomenon where AI makes things up, and it makes them up and it presents it quite convincingly. And so if you're using AI, but you actually don't have the experience to be able to call out where there's a hallucination, and we see it where, you do case law research and you ask it to summarize the law on X or Y, and it'll just create a random case based on something that's in the internet. So it can be flat out incorrect. So, that's something that where, there needs to be a human review of any document to ensure that there's no content that might just be flat out wrong. The information can be out of date. The ChatGPT forum went up to 2021, so it's in the process of being changed. So information that obviously was the internet after that, or legislative changes, just didn't form part of it. So it's limited by obviously the data that is in, whether it's ChatGPT or any of the other iterative AI that you're using. It can also produce biased and discriminating, or in some cases harmful content, just based on what it's picking up. And there's been a lot of work done to reduce that in the beginning, in the early stages when these products were being tested. It was producing quite a lot of racist, vitriolic hate, because that's essentially what it saw on the internet, on Twitter, and all of these extremist views. So there's been a lot of measures put in place. So if you ask it to do something that was racist, it'll give you a prompt to say that you can't now. That previously didn't exist, but it is still based on the content that's out there. Unfortunately, not all of that is fair or reasonable. It can be bad at maths. Don't assume that calculations are correct. You would have thought that that's kind of one of the straightforward things. It can be wrong after a few decimal places. And so you can't even rely on it in that. Transparency can be an issue. Confidentiality can be an issue as well. You don't want to put a whole lot of proprietary confidential information into ChatGPT so that it can write a letter that works for your circumstances, about an employee, about your business. And of course, the nature of it is that it's intended that businesses will have their own corporate platform, for example, of the Clayton Utz ChatGPT, and then we can put whatever we want in it. But presently, most people and organisations are just using the free version that is online. Context length was an issue where it could only produce up to 3,000 words. Now GPT-4 has increased that to 25,000. So that's about 50 pages of text. So it's pretty good now in terms of the length. And there were restrictions in terms of the what it could do as well, in terms of the computational requirements. So I don't know if you've had play around in it. I have. It's awesome. It's freaky. And you need to understand ChatGPT, because people will be using it in your organization, irrespective of what policies and positions that you might have in it. So in terms of liability, yes, there are risks. Australia doesn't have any statute that expressly regulates the use of AI, so there's nothing unlawful about using it. And there have obviously been some high-profile failures of AI, robo-debt, and other things where chatbots or AI are getting it wrong. So this slide just talks about some of the problems that you can have if you use it. Essentially, you need to ensure that you're using a trusted AI system, that you're protecting your data, that you have ethical guardrails or guidelines for your employees, and that you're transparent with your customers, clients, employees about where AI is being used. And really it is important to just institute end-to-end risk assessments that incorporate human reviews. So use it, but just make sure that there's a human that is checking. So importantly, you know, you need to be telling your junior staff that might be producing work for someone senior to let the boss know if they're using ChatGPT, because, you know, then they'll hone their attention probably in a more serious way than they might otherwise, if they're assuming that the lawyer, for example, in our case, has just done it based on case research. Now, you know, on one view, AI is probably less prone to errors than a human, but this hallucination risk is a very real one. I actually was on a panel about ChatGPT and AI with Toby Walsh, who's the chief scientist at UNSW, and he said something which really just stuck in my memory. He said, you know, we will not lose our jobs to AI. We will lose our jobs to people that use AI. So it is important that you get on board and start understanding it, because essentially the people and businesses that are using AI are going to outstep the businesses that aren't using it, law firms included. Okay, we are at the case study. So I'm going to do this very quickly so that we have some questions. This case related to a plaintiff, Mr. Shockman, who is engaged as a food and beverage supervisor on Whitsundays. His contract said that as part of his position, he needed to live in furnished share accommodation on Daydream Island. So it was a condition of his employment that he had to live in share accommodation with a colleague. Now, obviously, there's a whole lot of facts beyond that, but that's the starting point. He was living with a man called Mr. Hewitt rather, and they had a bit of a fight. Mr. Hewitt told him that he wasn't happy with management, and the facts go on from there. But as a first question, you can answer in the chat. Does this constitute the workplace, the accommodation that has been provided as a contractual requirement where you're mandated to live on the island in share accommodation? Do you think that constitute the workplace? And your options are on the screen. Look, lots of C's I'm seeing, and good. C is the right answer. I'm not gonna. I'm gonna give it. I'm gonna get straight through it, so that we can have enough time. In this instance, the High Court found that ultimately the accommodation was not the applicant's place of work, as the employees were essentially at leisure when they were in the accommodation. So the fact that it was provided as a contractual requirement didn't make it the workplace. So moving along, as I said, there was a little bit of an altercation between the two guys. One of them went off and said, "I'll leave you." So Mr. Shockman was left in the unit. He was actually one of the supervisors. Mr. Hewitt went out. He returned at 3 a.m., started vomiting, was semi-conscious in the bathroom and in a heavily intoxicated state. Mr. Shockman saw him, went back to bed. Then he woke up some stage later in the night, being unable to breathe because Mr. Hewitt was urinating on his face. Yes, you heard me correctly. He was urinating on his face. Mr. Shockman said that he yelled at him to stop, but was having a cataplectic attack, which is essentially a sudden onset of muscular weakness. And quite unsurprisingly, as a result of this episode, he said that he suffered post-traumatic stress as a result of the incident. So pretty intense set of circumstances. Proceedings were brought by Mr. Shockman on the basis that the employer breached its duty of care to him. And on the second tranche of the claim was that the employer was vicariously liable for the negligent act of Mr. Hewitt, I should say. So question 2, is Daydream Island Resort and Spa liable for the actions of Mr. Hewitt in weeing on his fellow employee and housemate? Lots of A's. A bit of a mixed bag on this one. I think I am seeing more A's than anything else. So again, 10 points. A is, thank God, the right answer, because there wasn't a proper connection between the employment and the act wasn't in any way authorised or incidental to the employment. It was found that the resort, Daydream Island, wasn't liable for the behaviours of Mr. Hewitt. Now, I wanted to mention this case, not just because it's a genuine nightmarish situation and a general HR horror, but because historically we have been talking in these sessions about the expansion of the workplace to social media, to after hours events. And so this was just a nice High Court case that made it very clear that there are absolutely behaviours of employees that the company, that the employer won't be held liable for. So the key takeouts is, again, you should be thinking about, you know, how expansive the workplace is, what is defined as the workplace when you're thinking about how you keep your employees safe. Ensure that your contracts don't specify position description or have things in there about, how work is to be undertaken. And so it's clear where something's in or outside of the worker's role. Have clear expectations of conduct. Obviously, most of us would have a code of conduct or things that make it pretty clear. Although I should say most codes of conduct don't specifically talk about urinating on your colleague, or at least not the ones that I've read. And of course, ensuring that complaints are taken seriously within your workplace.
I think this is, I know we've done quite a few of these sessions now, but this was by far the busiest. So we've still got, yeah, there's heaps. But look, thank you so much as always for such an amazing session. And so we'll send out the recording, hopefully probably early next week. We send it up to London and they do some fancy things with it. But look, please reach out to Cilla if you've got any more questions, which there seems to be. And I actually, because it's our sort of last event for the year, I just wanted to thank everyone, including you, Cilla, for everybody's support and participation in the events that we do face-to-face and online. And look, we hope to deliver some more interesting content next year. We've got quite a bit in the pipeline, so we look forward to doing that in 2024. But keep an eye on our website and LinkedIn, where we'll post updates on what's coming. And we're actually due to launch our salary survey that we did earlier in the year. It's been stuck in a bit of a pipeline of work, but hopefully getting that emailed out to everybody in the next couple of weeks. So that will definitely be on our LinkedIn page. So that's it from me. Thank you, Cilla, and enjoy the rest of your day wherever you are dialing in from, including Antarctica.
Thanks, everyone. We'll get that out to you as well.
Thanks, Cilla.
See you later.
Chat soon. Bye. Bye.